Hi, my name's Sam Tooker. I'm an attorney in Greenville, South Carolina at the law office David R. Price Jr., PA. I am here to talk to you today about the civil causes of action for malicious prosecution and false arrest. Now, we get a lot of calls from folks who contend that they've been wrongfully accused and wrongfully prosecuted for crimes they didn't commit, and they're interested in filing civil suits. Those are often difficult causes of action to bring. The primary reason for which is that the threshold is that there cannot be probable cause for the charge. And in general, when we're talking about bringing these causes of action, every now and again you're talking about bringing them against the complainant, and that's usually on shoplifting cases. You'd be talking about bringing a complaint against a storekeeper who wrongfully accuses you of shoplifting. But in the vast majority of these cases, what you're really talking about is a cause of action against law enforcement for charging you when there does not exist probable cause and there's an articulation that the charge is based on malice. When we're talking about these cases, what we're really talking about is a case where first you obtain an outcome that is favorable absent a not guilty at trial. So you've got to get a dismissal at preliminary hearing, a judicial dismissal for some other reason, a directed verdict at trial after the presentation of the state's evidence. You have to have one of those things where the court says this case is not good enough. So that's the first element or first box that has to be checked in determining whether or not you have a potential cause of action for malicious prosecution and false arrest. After that happens, you have to sit down and really look at whether or not there exists probable cause for the warrant. And I'll give you an example. There was a case tried in Pickens County. It was a murder case. And that was a murder case that was based on initially, I think, kind of factually controversial set of circumstances involving the death of a woman and whether or not that death was suicide or homicide. The person who was prosecuted, I think there existed a great deal of motive evidence, and that was sort of the basis for the prosecution. That motive evidence was excluded at trial, and the defendant won on directed verdict. So that is after the prosecution rests, the court says there is not enough evidence for this case to continue, so the case is dismissed. What happened in that case, to my understanding, is there was a civil cause of action brought, but the question with regards to probable cause was not what evidence was presented at trial, but what evidence existed and was in the hands of the prosecution and in the hands of law enforcement that related to the guilt or innocence of the defendant when they obtained warrants and when they indicted the case. So you can have a set of circumstances where you obtain a favorable outcome, but even obtaining that favorable outcome, there existed evidence sufficient to demonstrate probable cause, and probable cause is a relatively low standard for law enforcement action. But if there's evidence that demonstrates that probable cause, well, you don't have a cause of action for malicious prosecution. However, if there is a dearth of evidence of probable cause, if there is nothing that makes more likely to a reasonable and objective person that you committed the crime, then without that probable cause, then potentially you have an actionable cause for malicious prosecution. The next thing you're looking for is malice. And malice, when we talk about it in the criminal context, we usually say malice means meanness. In the civil context, particularly as it relates to malicious prosecution, what you're looking for with malice is, like I said, a lack of probable cause. And there's an inference of malice if the state chooses to prosecute a case for which there does not exist probable cause. Now, sometimes you can independently show malice. So maybe, an officer, an investigator has some prior dealing with a particular person, and by virtue of that prior dealing, is out to get them. Now, I will say in my experience that is highly unlikely, but it can happen. So that being the case, if you can demonstrate personal animus, some sort of personal grievance that would motivate an officer to prosecute a case for which there does not exist probable cause, well, then you've checked the next box. Final box is damages. How is it that by virtue of the decision to prosecute the case, a particular person has been damaged? Now, there are general damages, to my way of thinking, for having to worry about the charge being pending, having to stress out about the potential of conviction and incarceration. There are damages as they relate to what you have to pay for an attorney. There are damages as they relate to what you have to pay to bond out of jail. There are damages if you lose your job. There are damages if you lose your kids. There are damages that can be quantified based on any one of a number of things that can happen and often does happen or do happen when somebody is accused of a crime. Now, I say all that, here's a big caveat. if you've got a person who is charged on a bad charge, and immediately what happens is prosecution realizes, hey, this bad charge doesn't need to be prosecuted, the case gets dismissed, then it's not a great malicious prosecution case, because what happened is the system did what it was supposed to. The system ferreted out a bad charge. However, if you have a continued prosecution for an extended period of time, to my way of thinking, and that continued prosecution results in some damage to the defendant, and there does not exist probable cause, well, then that's potentially an actionable cause because your damages are greater. Your stress is greater. Maybe you've been incarcerated unlawfully. Maybe you've been falsely arrested, and that's the second cause of action that often accompanies malicious prosecution, false arrest, and that's detaining someone intentionally and without lawful authority. So if there's not probable cause and someone is unlawfully detained, the articulation is, well, that is a false arrest. That is a false detainment. That is an illegal detainment. And so what we're often looking for is not just a really, really poorly investigated case for which there does not exist evidence sufficient to demonstrate a particular defendant's culpability, but we're also looking for that defendant's personal harm, how it is that that defendant has been wronged by virtue of the false allegation. So if you can demonstrate both those things, and you think you have a case that demonstrates both those things, then we're happy to talk to you. Our phone number here is 864-271-2636. That's 864-271-2636. Like I said, my name is Sam Tooker. Give me a call. I'll talk to you about your case. If I think you have something, I'll tell you. If I think you don't, I'll be honest with you about that fact too. But it's certainly worth investigating, because quite candidly, I think in this day and age, if you don't hold law enforcement accountable when they do wrong, then it makes more likely that wrongs will continue and other people will be harmed. So like I said, if you want to talk, give me a call. I'm happy to sit down and talk with you. Thanks.